Hello, good evening, and welcome to Unacademy. GS Paper 2 deals with polity, governance, social justice, and international relations. This is our masterclass on GS Paper 2 Answer Writing, extremely helpful for those attempting mains this year, but also helpful for those who are planning to attempt in 2027 or beyond. 20 questions in 180 minutes, which means roughly 9 minutes a question. But you don't have to follow that approach. You need to ensure that you're finishing the question paper 15 minutes in advance, which means 165 minutes. Is it possible? Yes. Is it difficult? Slightly difficult, but make it possible. How? Hitler, not the example that you should quote, but Hitler would say, tell a lie, make the lie big, keep on repeating it, and eventually people will believe it. Amir Khan said in Three Idiots, all is well. So you'll have to fake it to your heart so that your heart understands it. Or as Mirza Ghalib would say, हमको मालूम है जन्नत की हकीकत लेकिन दिल के खुश रखने को गालिब ये ख्याल अच्छा है. Which means if you keep telling yourself that I can finish this question paper in 165 minutes, and if you keep that as your target, eventually you will keep in mind that you have only 165 minutes to attempt this question paper and you will chase that target. What are you going to do in the remaining 15 minutes? Keep that in mind. One, maybe you will revisit the questions you have skipped. You will complete the conclusions of other questions. For example, you're writing an answer, but you have not completed the conclusion or added a value-added point. Maybe in these 15 minutes, you can revisit those questions, give a proper conclusion, underline important keywords, and that is going to differentiate your answer from your competitor. Because after all, you don't have to just present a dish. It should be garnished in such a manner that it appears beautiful as well. So keep that in mind, 165 minutes to answer these 20 questions, which means you don't have to devote equal amount of time to all these questions, because there are questions you will have to answer in 150 words. There are questions you will have to answer in 250 words. If you can answer the 250 words question in 9 minutes and 6.5 minutes for 150 words question, more than enough. But keep in mind, you must target that I will finish my question paper 15 minutes in advance so that I can focus on these areas. But listen to me carefully. As I told you, it's polity, governance, social justice, international relations. More often than not, what happens, aspirants, candidates, they tend to focus on polity areas. They devote more time in finishing these polity questions, and ultimately they skip many questions. Or they do not answer other questions properly. Leave out international relations or social justice type questions. Don't do that. How you can solve this problem? Once you read the question paper, maybe you can try EMD. Mark the questions as easy, moderate, and difficult. Initially focus on those questions which you can easily answer. Maybe you have practiced that in your mocks. Maybe you have a ready-made answer available for these questions. Maybe these questions are part of your forte. So focus on the questions first which are easier, then moderate, then difficult. Clear? Do not unnecessarily chase polity questions and try and write a perfect answer. Because please keep in mind, let perfect not be the enemy of good. You should write a good answer, to the point answer, rather than chasing perfection. Because what ideally you should chase is finish the question paper. Once you have finished the question paper, then you can attempt perfection in the last 15 minutes by writing an optimistic conclusion, a better conclusion, way forward, underline important keywords, or maybe you can finish those questions which you will have skipped. This is where last 15 minutes will play a very important role. Keep this in mind. For example, I will ask you write a note on the office of governor. For example, such a question would not be asked in the examination, but just for your understanding. Write a note on the office of the governor. Now, who is that candidate who will fetch poor or average marks, and who is that candidate who will fetch good marks, maybe more than 55%, 60%? What's the difference? What's the differentiating factor? If you're going to write a poor or an average answer on this particular question, write a note on the office of the governor. Someone will focus on articles, write articles of the constitution dealing with the office of the governor, explain all these provisions. This is not going to fetch you marks. But those who will get and fetch good marks for such a topic, for such a question, what will they focus on? What is the constitutional role of the governor? And then branch out, look at the recent controversies. Maybe include the example of the governor of Tamil Nadu delaying the swearing in of Mr. Vijay as the chief minister of Tamil Nadu because he was not convinced that he has the numbers. Should these numbers be proven on the floor of the Legislative Assembly, or these numbers should be proven on the floor of the Lok Bhavan? That's a critical question. What are the Supreme Court judgments on this particular topic? Federalism concerns, because after all, governor is appointed by the center. Sarkaria Commission and Punchi Commission recommendations. Or you can even cite the Kurian Joseph Committee recommendations, the latest one which was set up by the state of Tamil Nadu. That's also a value addition point. And then a proper solid way forward. This is just a template, just how I can differentiate between a poor or an average answer and a good answer. Because you need to widen your mindset, widen your horizon, and look at multiple angles for that particular question and then answer it. This is the approach that you need to follow. Maybe there are some committee recommendations. Maybe there are Supreme Court rulings. Maybe there is important development which has taken place. That's something that you have to keep in mind. And this is exactly how we are going to approach Conquer Mains program for those attempting Mains 2026. This Conquer Mains program would start on the 8th of June. I'll start with Polity. Those who are already enrolled with us, you will get access to this Conquer Mains without any additional charge. But those who are not part of the Unacademy family, and should you wish to enroll in Conquer Mains, the window is available. This program is available at 9999. Let's focus on today's lecture. One topic from which I expect a question in the upcoming mains examination is this: 10th schedule, anti-defection law. Questions on this topic have been asked previously in the mains examination, and because of the controversies that we saw recently when it comes to, let's say, the Raghav Chadda episode, or what is happening in Tamil Nadu because of AIADMK MLAs supporting the TVK government, all these raise important questions about the efficacy of anti-defection law. But if you read, or if you would have noticed the mains question paper last year, sometimes UPSC tends to dig too deep into the provisions and will ask you questions specific to a particular provision. How do you understand this topic in great detail, keeping in mind the upcoming mains examination? That's what I'm going to tell you today, demonstrate today, and later I will also give you a list of questions, probable questions that can be framed from this particular topic. First things first, anti-defection law. What are the provisions of this law? If at all a question is asked, what are the provisions of anti-defection law? Simple, one line in that question. Maybe the question is broken into 3 or 4 parts. One part of this question is, what are the provisions of anti-defection law? Why was it framed? Can you draw a diagram? Let's say this is anti-defection law, 52nd Amendment, 1985. This is how this is when this law was enacted. 10th schedule of the Constitution. Now, what is the purpose of this law? The purpose of this law is to ensure political stability, to curb defections in our party system. This is the purpose of this law. Political stability, ensure the stability of the elected governments. That's why this particular law was enacted in 1985. If you look at then the provisions are, what are the grounds for disqualification on the grounds of defection? This is where some of you may have a concern, may have a problem. Should I write the entire statement or should I write in keywords? For example, grounds for disqualification on the grounds of defection. Who will be disqualified? Number one, voluntary resignation. If a member of a house belonging to a political party voluntarily resigns from his political party, disqualified. Voluntary resignation is a ground for defection, is a ground for disqualification on the grounds of defection. Violating the whip, which means if the whip issued was, you have to vote in favor of this no confidence motion. If you vote against, it is violation. If you abstain from voting, it is also violation, which means that becomes the ground for disqualification. Without going too much into details, such as even if you are violating the whip, you have 15 days, your political party has 15 days to condone your violation. And that too, the party should give it in writing to the speaker that we condone the violation of the whip issued by us to this particular legislator. You don't have to necessarily go too deep into that because then you are violating and crossing the word limit. What are the provisions? Focus on the provisions. See, independent member, joining a political party. That's also a ground for disqualification. Then D, nominated member joining a political party 6 months after the nomination. You can write it in points. You can probably draw a diagram because of the limited space. I could not do that. And then you have to also discuss who is the decision-making authority. And the decision-making authority is the chairman or the speaker, as the case may be. Which means the examiner will know that you are talking about Speaker of the Lok Sabha or the Legislative Assembly, Chairman of the Rajya Sabha or the Legislative Council. These are the provisions of this law, broad provisions of this law. But what sort of questions can be framed from this topic if UPSC will not ask you about the provisions? How deep can UPSC dig into this particular topic? That's something that we need to discuss now. Listen to me carefully. Merger versus split. Now you tell me, if a question is asked, how far do you agree that if the 2/3 legislators of a political party join another political party, they are saved from disqualification under the provisions of the anti-defection law? Elucidate by citing relevant case laws. Do you know, or do you feel, or do you believe that the resignation of Raghav Chadha and 7 MPs of the Aam Aadmi Party and their joining the BJP, does it constitute a valid merger of this legislative wing with that of the BJP as a political party? That's an important constitutional question. Unless and until you know the case laws, you will not be able to fetch good marks. What if the UPSC wants to stump you, what if UPSC asks you, comment on paragraph 4 of the 10th schedule of the Constitution? Now you're struggling with, what is this paragraph 4? What does it deal with? So you need to keep in mind, since it deals with something that has happened recently, it is related to the merger or split. First, you need to understand there is no provision of a split in anti-defection law. No provision. There used to be a provision. There used to be a provision where if 1/3 members of a legislative, of a political party join another political party, they would be saved from disqualification. So that was split. If there is a split in a political party, if there is a split in the legislative wing of a political party, if 1/3 of them decide to join another political party, they will not be disqualified because they are saved from disqualification. But this provision of a split was removed by a constitutional amendment, 91st Constitutional Amendment 2003, when Mr. Vajpayee was the Prime Minister. Clear? So there is no such thing as a split in a political party recognized by anti-defection law. That's something that you have to keep in mind. Instead, what anti-defection law as it stands today deals with, talks about, is a merger. And that is something which is mentioned under the paragraph 4 of the 10th schedule of the Constitution. And it talks about twin test for a merger. There are two tests which need to be satisfied. First, there has to be a merger of political parties. Then the test number 2 is 2/3 members of the legislative wing of that political party should condone and accept this merger. This twin test is a requirement under paragraph 4 of the 10th schedule. What is test number 1? There must be a merger of the original political party with another party. So Aam Aadmi Party and BJP at organizational level should have merged. Second condition is, then 2/3 of the members of the Aam Aadmi Party should agree with this merger, and as such they will be saved from disqualification. This is a twin test under paragraph 4 of the 10th schedule. But what are the case laws related to this? Unless and until, if this question is asked, you don't cite this judgment, your answer would be worthless. This is a very important judgment. This is related to the Shiv Sena case, where a 5-judge constitution bench headed by the then Chief Justice, Justice Chandrachud, gave this verdict. This 2023 Constitution Bench judgment, and what is the case name? Subhash Desai, the Principal Secretary of the Governor of Maharashtra. In this case, the Supreme Court clearly said that there are distinguishable concepts. Legislative wing and organization wing. These are distinguishable concepts. So you can't treat what is mentioned here. If the political party merges with another political party, is the political party same as the legislative wing of that political party? No. Legislative party is the subset of the original political party. Original political party needs to merge with another political party. And then this merger should be supported by the 2/3 of the legislative wing. Can we assume and equate that this legislative wing itself is a political party? No. Who said this? A Constitution Bench judgment of 2023 in the Shiv Sena case, and the name of the case is given here. What if you are asked, answer this question by citing relevant case laws, and this is a case law that you need to cite. Although it was not specific about merger, this case was not about merger of political parties. Keep that in mind. But what this case was all about is whether you can equate a legislative wing with that of an organizational wing. Because of various details, we don't need to go into that because that would drag this lecture unnecessarily. This case was not about merger. But even if this case was not about merger, this case spoke volumes about this concept that we can distinguish, and these two are distinguishable concepts. One is the legislative wing, the other is the organizational wing. But another important case, Bombay High Court, there was 2/3 members of the Congress party decided to merge with the BJP, and the Speaker of the Goa Legislative Assembly said this is a valid merger. Same was said by the chairman of the Rajya Sabha in the Raghav Chadda case, Aam Aadmi Party case, and the chairman said this is a valid merger under the 10th schedule. But this matter right now is sub judice. This matter right now is sub judice. Why? Because there are conflicting views. One view is this, and the view of the Bombay High Court, which was Bombay High Court upheld the decision of the Speaker of the Goa Legislative Assembly, where the Goa Legislative Assembly Speaker upheld this case as a valid merger of these MLAs with the BJP. The other is the Constitution Bench. Although it did not directly deal with merger, but it says that legislative wing and organization wing, these are distinguishable concepts, which means even this Bombay High Court judgment is now challenged before the Supreme Court. So if you are asked this question, what is the status? How far do you agree that 2/3 members of a legislative wing joining another political party saves them from disqualification under the 10th schedule of the Constitution? Or how far do you agree that paragraph 4 of the 10th schedule of the Constitution allows 2/3 of the members joining another political party without attracting disqualification? You should know that this matter is sub judice. On this matter, there is no finality of the judgment of the court. Unless and until you mention this, you will not get enough marks. You will not get good marks because you have to be in know of what is the current legal status on this matter. That's number one. That's one type of question that can be framed on this topic, anti-defection law, strictly for your mains examination. Something else. Resignation is now a loophole. And then the acceptance of the resignation by the speaker is another issue. I am telling you, sometimes the UPSC tends to go too deep into the concepts. And this is where the students stumble. We know what is anti-defection law. We know the provisions. We know speaker is the decision-making authority. But exactly this specific question which was asked, I'm unable to understand because it went too deep into that concept. UPSC doesn't go deep unnecessarily. There is always a link with current affairs. Resignation. 91st Constitutional Amendment Act in 2003 said a defector cannot hold any remunerative political post, which means a defector cannot be made into a minister, cannot be made a minister. That's a condition. But that's for a defector. Look at it this way. I am a Congress MLA or a Congress MP. Now I want to join the BJP. If I join BJP, I will be disqualified. Instead, what I can do is, but I want to be a minister. If I join BJP, can I be made a minister? No, because I'm a defector. And there is a clause. The clause says I cannot be holding any remunerative political post for the remainder of the term of that legislative assembly or till the time I am re-elected, whichever is earlier. Long story short, in order for me to become the minister, to be made a minister, I have to either wait for the next term of the Legislative Assembly or I have to get re-elected because I'm a defector if I'm disqualified under anti-defection law. But to save myself from disqualification, what I do, I resign. When I resign, I'm not subject to anti-defection law at all. Because under anti-defection law, what would have happened? I would have been unseated. I would have been disqualified from that house. I'm not resigning from party. If I resign from party, I will be disqualified. I resign from the house. If I resign from the house, is anti-defection law still relevant here? Depends upon the timing. Timing. Did disqualification get attracted first or my resignation? Chicken and egg problem. Who comes first? Resignation or my disqualification? In a sense, taint of defection is not vaporized by resignation. Comment. What if this question is asked in the examination? You will take some time to even understand the gravity of this question. Does the acceptance of the resignation render the disqualification proceedings infructuous, meaningless, pointless, regardless? That's the question that we have to keep in mind. And this is something which has happened. Happened when? Shrimant Balasaheb Patel and others, we Speaker of Karnataka Legislative Assembly 2019. You don't have to go too deep into what happened there, but this case law is very important. This case law is very important. Now look what happened. There is JDS Congress government in Karnataka. And then there was Operation Lotus. Operation Lotus, you don't have to mention that in your answer. Operation Lotus, where the BJP is trying to poach MLAs so that they are able to form the government. Okay. What some of these MLAs belonging to the JDS and Congress do, what they do, they don't participate in the meetings of the Congress party. They don't participate in the meetings of the Congress party. And then when they realize that maybe by not participating in the meetings of the Congress party, we may be disqualified under anti-defection law. Sir, what are you trying to say? What does this phrase mean when it is mentioned in anti-defection law, voluntary resignation? It's not defined in the Constitution. What is this voluntary resignation? Does that mean I have to formally submit my resignation to the Speaker? And that would, I have to submit my resignation to my party. That would mean I'm formally resigning from my party. Or does it mean I am not submitting formal resignation to my party, but I am not participating in the meetings of the party. I am attending the meetings of the different political party. I am attacking the policies and the programs of my political party. Can it be viewed that the conduct of a legislator outside the house is such that we can assume that you have defected, you have voluntarily given up your membership of that political party? This, the court has held, is valid. Valid in the sense, Ram Naik case, Keshav Prasad Maurya case, Tamil Nadu Legislative Assembly case, so many cases where the courts have categorically stated that if I, Sarmad Mehraj, am part of the Congress as a legislator, I am not resigning from the Congress. Because if I resign from Congress, I will be disqualified. But I'm not resigning from the Congress, but instead what I'm doing, I'm attending the meetings of the BJP. I'm criticizing the policies and the programs of the Congress. Can this be the ground of disqualification? Yes. Because formal resignation does not matter. Your conduct outside the house is such that we can assume that you have voluntarily given up the membership of your political party. You will be disqualified. So these MLAs, these 17 MLAs, they thought that if we are not attending the meetings of our political parties, the speaker who belongs to the Congress, he may assume, yes, you have voluntarily given up the membership of your political party, I will disqualify you. And they sensed that they may be disqualified. And what they did, they resigned. Now look at the timing. What has happened first? Chicken and egg problem that I was talking about. What has happened first? Your resignation first or your misconduct first? What happened first? Did you resign first? No. What happened first? You stopped attending the meetings of your party. You were called for the meetings and you were not attending. You are attending the meetings of the different political party. The speaker will be now asked by the party that could you please disqualify these MLAs? And now do you preempt it? You preempt that speaker may disqualify me. And to save myself from disqualification, I want to resign from my party. Now you might say, what is the difference, sir? Resignation and disqualification is the same. If you resign, you can still be appointed as a minister. But if you are disqualified, you cannot be appointed as a minister unless and until the term of the legislature is over or you are re-elected, whichever is earlier. So if you want to be part of this new BJP government, but you are already part of the Congress, don't attract disqualification, instead resign. Resign and you can be made a minister. And that's what these MLAs tried to do. But when matter went to the Speaker of the Karnataka Legislative Assembly, Speaker said you are disqualified. I am not going to accept your resignation. I will disqualify you. And I am going to disqualify you for the remainder of the term of the Legislative Assembly. Which means for the next 3 years or the remainder of the term of the Legislative Assembly, you cannot even contest election. You cannot even recontest. Matter went to the Supreme Court. Supreme Court said this disqualification of these legislators is constitutional. Why? Because look at the timing. What came first? Their resignation or their misconduct where they are not attending the meetings of the party? But Speaker of the Karnataka Legislative Assembly, we disagree with you. You are disqualifying them for the remainder of the term. This is not valid. Why? Because you cannot invent a disqualification period. Constitution under anti-defection law states that you will be disqualified either for the remainder of the term of the Legislative Assembly or till you are re-elected, whichever is earlier. How can the Speaker invent a disqualification period and tell you that you are to be disqualified for the remainder of the period? No, but your disqualification is valid. But you can contest election. And they contested the election and most of them got re-elected, which we will discuss later. But there were two important observations in this case by the Supreme Court. It's a very important case because this matter went to the Supreme Court. Comment upon The role of the speaker in anti-defection law. Now you might think this is a straightforward question. The role of the speaker is you can disqualify. Time limit is not mentioned in anti-defection law. But if you just follow this route in answer writing, you will not get good marks. To fetch good marks, you have to cite this. Because when you submit resignation, does it vaporize disqualification? Should speaker accept the resignation? These are critical, minute details that you have to keep in mind for answer writing. What if the question is too deep? Speaker's role in considering a resignation was limited, says the Supreme Court in Karnataka case. He could only ascertain if the resignation is voluntary or under duress. When initially, if a legislator had to resign from the House, you had to submit the resignation to the speaker and the speaker would accept it. Then we saw in Gujarat Navnirman agitation in the 1970s, when public protests were forcing legislators to resign, which means under duress legislators were resigning. 33rd Constitutional Amendment Act was passed in 1974. And that 33rd Constitutional Amendment gave a power to the speaker that their speaker, before accepting the resignation, you have to decide whether the resignation was voluntary or was it coerced. Unless and until you are satisfied that this resignation is voluntary, genuine, not under duress, not coerced, you should accept the resignation. In Karnataka case, the Supreme Court said, what is the role of the speaker? The role of the speaker is you just have to see whether the resignation was genuine or not. If it is demonstrated that this member is resigning out of his or her free will, you have no other option but to accept the resignation. So I cannot as a speaker go into the motive of the legislator. Why are you trying to do this? Are you going to be part of a new government? Are you going to join a new political party and because of that I will not accept your resignation? No. You just have to see that whether this resignation was voluntary, genuine, nobody forged your resignation letter, you have to accept the resignation. But the taint of disqualification does not vaporize just because of resignation. If you are resigning now, speaker will accept the resignation. But before resigning, if you had stopped attending the meetings of the party, you have spoken against the political party, or you have violated the whip of the political party, then you will be disqualified even if you have submitted the resignation. The submission of a resignation letter does not render a pending or an impending disqualification action infructuous, useless, pointless. No. This is a very important point you have to know if you have to score well in the mains examination. But first up, the court noted that there is a second consequence to defection. And what is that consequence? Apart from the loss of membership, which obviously if you are disqualified, you will lose the membership of that house. But another consequence of defection or disqualification is you cannot be appointed as a minister, you cannot hold any remunerative political post until the end of the term or till you are re-elected, whichever is earlier. What is the context? 4 MLAs of the AIADMK, maybe tomorrow 25 MLAs of the AIADMK, they have voted against the party whip. AIADMK as a political party issued a whip, and this is something that was decided by the Subhash Desai case by 5-judge bench of the Supreme Court in 2023, the Shiv Sena case. The court categorically stated who can appoint a whip. Will whip be appointed by the leader of the legislative party or leader of the political party, organizational wing? The court categorically stated that the prerogative of appointing a whip is the political party, is with the political party. So political party AIDMK issued a whip, a directive to all its MLAs that you have to vote against the confidence motion. 25 MLAs voted in favor of the confidence motion. What does it mean? It means that you should be disqualified. What if later they resign? Does the resignation make the disqualification proceedings infructuous? No. Because we have to look at the timing. And the timing is, first you violated the whip and then you resigned. Even if now you resign and it is accepted by the speaker, that does not mean that the disqualification proceedings become infructuous. Because there is a difference between resignation and consequence of a resignation and disqualification. If you resign from the house, then you are not subject to anti-defection law. Which means you join after resignation, you join a political party, you can be made a minister. But if you are disqualified, you cannot hold any remunerative political post for the remainder of the term or unless and until you are re-elected, whichever is earlier. This is what the Supreme Court has categorically stated in this case. So what is the crux of this case? The Karnataka case, where you are resigning, although there were disqualification proceedings pending against you, but now you are resigning. What does it lead to? Look at the crux. And this is something that you have to remember and memorize. Interplay between disqualification and resignation. The speaker may disqualify a person if the defection occurred earlier, but does not mean he could reject a voluntary and genuine resignation by delving into its motive. What is the interplay between disqualification and resignation? The speaker may disqualify you if the defection has occurred earlier, if the AIDMK MLAs have violated the whip earlier. But even after that, you have violated the whip, but I will still submit my resignation. Can the speaker refuse to accept my resignation only because I had defect or disqualification proceedings are pending against me? No, I just have to check as the speaker whether this resignation is genuine or not. I will have to accept your resignation if it is genuine, if it is not forged. Even then I have to proceed against you under anti-defection law. And what if the speaker says, no, since I have accepted your resignation, and now I will not proceed against you under anti-defection law, because what's the point? This decision of the speaker is subject to judicial review. And Supreme Court has categorically stated in 1993, judgment that I will cite later, Kyoto Holohan v. Zachilhu in 1993, Supreme Court said judicial review is part of the basic structure. So the decision of the speaker is acting as a quasi-judicial body, like a tribunal, to decide, because after all, it's a judicial work that you're doing, whether you should be disqualified or you should not be disqualified. I, as the speaker, am acting in a quasi-judicial capacity. My decision is subject to judicial review. And that's what the Supreme Court said in Kyoto Holohan v. Zachilhu, 1993. More. Nabam Rebia case, another important case that you have to keep in mind. I am an MLA or a legislator. I want to defect. I want to join another political party. But I am worried about the speaker, because the speaker has the power to disqualify me under anti-defection law if I violate the provisions of the 10th schedule. How do I solve this problem? I, along with other MLAs who want to defect, we don't defect. First, what we do, although we are not attending the meetings of our political party, we are a group of disgruntled legislators. We are not attending the meetings of the political party. It is almost certain that we will defect. And now what has happened is, political party tells the speaker that you disqualify us. Because although they have not submitted formal resignation letter, but with their conduct, we can assume that they have voluntarily given up the membership. So please disqualify them. Now who will disqualify us? Speaker. To prevent the speaker from disqualifying us, what we do is, we introduce a motion calling for the removal of the speaker. We introduce a motion calling for the removal of the speaker. Now you tell me, should the speaker take a decision on our disqualification when the motion is also pending in the legislature, in the house, that the speaker himself should be removed? If I disqualify that, imagine it this way. If I'm the speaker, you 10 are the disgruntled MLAs, I have to disqualify you. And you introduce a motion calling for my removal. I will first disqualify you because I know you will vote against me. This can also be the case. Or the converse case can be, since these 10 MLAs should be disqualified, they are introducing a motion calling for my removal. Which means their intention is to deactivate the office of the speaker. This was decided by the Supreme Court in the Nabam Rebia case in 2016. It was related to the crisis in Arunachal Pradesh. The Supreme Court said, if a motion is pending against the speaker, if the motion calling for the removal of the speaker is pending in the House, this speaker cannot act under the provisions of the 10th schedule. Long story short, if I am the speaker, I am a quasi-judicial body when it comes to deciding disqualification petitions. But if a motion calling for my removal is pending in the House, I cannot decide on disqualification petitions. Who said this? Nabam Rebia case. But even this Nabam Rebia case is now under review. What does it mean? Another type of question. How far do you agree that the speaker acting as a quasi-judicial body cannot act under anti-defection law if a motion calling for his removal is pending in the House? Answer by citing relevant case laws. Now, by reading this question, you will be stumped. Where is this question coming from? We have read about anti-defection law. We read about the role of the speaker. But what is this intricacy? What is this minute detail that if the speaker has to decide on disqualification petitions, but a motion calling for his removal is pending in the House, he may or may not act against? This is related to Nabam Rebia. But what is the current legal position on this? This matter is under the review by the Supreme Court. A wider Supreme Court bench, 7 or 9 judge bench, is going to decide this matter to review the Nabam Rebia case. Because it becomes easier for a disgruntled MLA to stop proceedings under anti-defection law. You want to remove me, but now I am introducing a motion calling for your removal. And Nabam Rebia case allows me that if a motion is pending against the speaker calling for your removal, you cannot act on the disqualification petitions under the 10th schedule. That's another important matter. Something else. There are other problems with anti-defection law. For example, I was telling you, ambiguous phrase like voluntary giving up the membership. Does it mean formal resignation? Or does it mean the conduct of the legislator outside the House? This voluntary resignation is not defined. Then we go for the interpretation of this provision by the Supreme Court. Ram Naik case, Tamil Nadu Legislative Assembly case, Keshav Prasad Maurya case, all these cases, they categorically say that voluntary giving up the membership means what? It does not mean that you have to formally submit your resignation. Your conduct outside the House is such that we can assume that you have voluntarily resigned from your party. There is no timeline for the speaker either. The speaker delays the disqualification petitions. That's something that you are aware of. Judicial intervention is becoming frequent. Arunachal case, Manipur case, Goa case, Karnataka case. So you are wasting judicial time. Interplay, look at, widen your scope. Interplay. If the law is amended suitably, by ironing out all these problem areas, we are going to save the time of the judiciary. Fix the timeline on the speaker. delays in disqualification proceedings, which is similar to no timeline for the speaker. These are concerns. Then what is the way forward? Something which is recommended by a two-judge bench of the Supreme Court. I am going to cite the case name later. Justice Rohinton Fali Nariman was the judge. He said, look at the irony. How can we even assume that the speaker is going to be impartial in deciding these disqualification petitions when the speaker continues to be the member of the ruling political party? It's beyond us to even assume that the speaker will be impartial in deciding these disqualification petitions. At the same time, he is a member of the ruling party or the ruling coalition, and he is also heading this tribunal as a quasi-judicial body to decide these disqualification petitions. And that is why, in that case, the Supreme Court nudged the Parliament, amend the law. Amend the law so that we can transfer this responsibility to an independent tribunal, where the speaker should not have any role. Let's create a separate body to decide these disqualification petitions, a separate tribunal, just like we have tribunals for other matters. We should have tribunals on this matter. Or give this role to the Election Commission. If you are to be disqualified as a legislator on the grounds of office of profit, change in the nature of citizenship, adjudged insolvent, this matter is decided by the President or the Governor, who act on the report of the Election Commission of India. Then why should we entrust the speaker, who continues to belong to the ruling party because he doesn't resign? He's still part of the party. He's still part of the ruling party. He's still part of the party in power of the coalition. Why should we give him the responsibility to decide on these disqualification petitions? We should entrust this matter to Election Commission and make it time bound. The Supreme Court in one case had said time limit should be 3 months. 3 months is an ideal time to decide on these disqualification petitions. But that was only the nudge by the court. That was not part of the verdict. More. Whip is one of the most important and problematic areas of anti-defection law. The question has been asked previously. The quality of debates in the Parliament is declining. How far can this be attributed to an anti-defection law which was passed for a different purpose? I am a legislator, elected by the people of my constituency. But because of anti-defection law, I become part of, I'm bound by my party high command. I cannot have my individual viewpoint. I am part of the Congress, but I want to support the Citizenship Amendment Act. My party tells me, don't do that. I cannot. I am part of the BJP, but I don't support the farm laws. But the party tells me, no, you have to support. If you don't support, we will disqualify you. This whip, which is made binding on the legislators for numerous things, should this whip be binding in all cases? Or should it be binding only in those cases where the stability of the government is under threat? Where is the stability of the government under threat? In no confidence motion, in confidence motion, in adjournment motion, in motion of thanks for the president's or governor's address. If those motions are defeated, the government has no other option but to resign. But if a bill is defeated, the government does not have to resign. So make anti-defection law. Look at the purpose of this law. The purpose of this law was to ensure political stability. But instead you are making these legislators the pawns of the political party. Party high command culture. Make this whip binding in cases where the stability of the government is under threat. For example, confidence motion, no confidence motion, motion of thanks for president, vote of thanks for president's or the governor's address, adjournment motion. In all other cases, it should be made optional. So that I, as a legislator, I can also have my own independent voice. Who said this? Dinesh Goswami Committee on Electoral Reforms 1990. Who said this? There is a private member's bill introduced by a private member, Manish Tiwari. Law Commission of India said in its 170th report, I think it was 1995 or 99, Law Commission of India 170th report, dissent within political parties. One important thing, listen to me carefully. Sachin Pilot was disgruntled one. He was the Deputy Chief Minister of Rajasthan. He was not too good, or the relationship soured between him and the Chief Minister, Mr. Gehlot. And then he went to Haryana along with some of his 17 MLAs, which was considered to be an act of rebellion. The Speaker of the Rajasthan Legislative Assembly issued a show cause notice to Sachin Pilot and other MLAs. Why action under anti-defection law cannot be taken against you? They were not disqualified, but they were issued a show cause notice. Tell us why you should not be disqualified, because we feel that you have voluntarily given up the membership of your political party, because you're not attending the meetings of the Congress. You're attending the meetings of the opposition maybe. Against this show cause notice, matter went to the Supreme Court. Harish Salve was a lawyer for Sachin Pilot, and Harish Salve is thundering before the court. My lord, what is the role of dissent in a political party? Political party will have different leaders, part of it. They will have disagreements. My clients, Sachin Pilot and other MLAs, they have not resigned from the Congress. They have not voluntarily given up the membership of the Congress party, but there is disagreement within the Congress party on certain policies and the programs of the government. Can disagreement be equated with that of defection? That's a critical point. And this is something that this Law Commission report also had highlighted. We need to ensure democratic functioning of a political party, wherein there is dissent, there is disagreement. One group may agree, the other group may disagree within a political party. But the architecture of anti-defection law is such that a mere disagreement can be equated with that of defection, and this group may be disqualified under the provisions of the 10th schedule. That is why don't make whip binding in all cases. Don't consider disagreement or dissent as defection. Law Commission report. Supreme Court observation in the Manipur case. And this is the case that I was talking about, where a two-judge bench of the Supreme Court, headed by Justice Rohinton Fali Nariman, is nudging the parliament that you should amend the law. Because I can't agree, or I can't even understand, that a speaker who is acting in a quasi-judicial capacity to decide on these disqualification petitions, while at the same time he continues to be the member of the ruling party or the coalition. That is why you need to entrust this responsibility to an independent tribunal. Without explaining all these things in detail, you can just mention this was another reform suggested by the Supreme Court in Manipur case, wherein the court nudged the parliament to amend the law. In fact, in this case, the court invoked Article 142. T. Shyam Kumar, I'm slightly digressing, but this story maybe becomes important so that you're able to recall it, retain it at the time of the examination. Mr. T. Shyam Kumar was elected as a legislator in Manipur Legislative Assembly on the Congress ticket. But then the BJP formed the government. And T. Shyam Kumar defected, joined the BJP, and was made a minister. He was made a forests minister. Petition was filed before the speaker that please disqualify T. Shyam Kumar. He's not disqualifying, because there is no time limit. The role of the judiciary also becomes weaker, because judiciary has the power of judicial review. Judicial review means first speaker has to act. If he is acting, if he is disqualifying you, or if he is ruling that I'm not going to disqualify you, only then the court can enter into the picture and review the decision of the speaker. But how can the court intervene in a pre-decisional stage, before the speaker takes a decision? The Supreme Court bench gave time to the speaker, decide. The speaker is not deciding. Decide, not deciding. He's asking for more time. More time, more time, more time, multiple sittings of the court. And finally the Supreme Court said enough is enough. We are invoking the plenary powers under Article 142. so as to give complete justice in this particular case. T. Shyam Kumar, you are removed as a minister, and don't you dare enter the Legislative Assembly unless and until disqualification petition is sorted for you. Timeline was given to the speaker that now you decide, otherwise contempt proceedings will be filed against you. And the speaker disqualified T. Shyam Kumar. This is where we mentioned judicial intervention becoming frequent. I had a value point wherein in one matter the Supreme Court had to invoke Article 142 bracket Manipur case to decide a disqualification matter. You're wasting the time of the court. That's why there is a need to amend the law. But be that as it may, another matter. Any questions as of now? No? Okay. You elected me from a constituency, and I'm now part of the legislature. Then I violate your trust. I join another political party. This talks about morality or immorality in politics. Quote Mahatma Gandhi. Mahatma Gandhi believed in the morality in politics. He believed politics divorced from morality is a death trap. And legislators jumping the ship, Ayaram Gayaram, defection, violates Mahatma Gandhi's philosophy of political morality. Another value addition. Edmund Burke's trustee model. Very important concept. Edmund Burke, Irish, British. Trustee model. The people of my constituency, they send me to legislature. They send me to legislature with a hope that you will not do what we will tell you to do. In this model, trusteeship model, my constituency elects me, sends me to the legislature, but not with this hope that I will do whatever you tell me to do. No, I will have my own conscience to decide what is good for the entire nation, not only for my constituency. That's the trustee model. Which means under this Edmund Burke's concept, legislator has a conscience. But what happens to my conscience when a whip is issued against me? You can't vote on this matter based on your own conscience. You have to vote on the basis of the diktats of my political party. The provision for a whip being made binding in all legislative matters violates the Edmund Burke's trustee model. When you add such points, examiner will also feel, wow, it's a very good answer. And that's what should ideally differentiate your answer from the others. Right or wrong? Right. Economic costs. Don't just look at anti-defection law from the perspective of the law. There is a social dimension to it. Mahatma Gandhi's concept, morality issue, social issues. Because of this, a sense may get developed in the society that this is all okay. You are corrupting the society. It has an impact on the psyche of the people. But look at the multidisciplinarity of this topic. It has economic costs as well. These 4 AIADMK MLAs resigning before the term or getting disqualified and then contesting the election again, it's torture for the voters. because now they will have to vote again. It is having its own economic costs of by-polls, by-elections. That's another issue. From whatever we have discussed till now, I will now give you a list of probable questions that may be framed from this topic. And you tell me whether you will be able to answer it or not. Do you agree that the anti-defection law prioritizes party discipline over representative democracy? Discuss. The role of whip, Edmund Burke's concept, trustee model, voting as per your own conscience. Right or wrong? That's number one. Number two, discuss the tension between freedom of speech of the legislators and party discipline under the 10th schedule. Look at it this way. The legislators shall have the freedom of speech. Article 105. No matter what you say and how you vote, as a legislator, you cannot be held answerable in any court of law. This is to ensure that the legislators are able to freely discuss problems concerning the nation or their constituency. But what anti-defection law does? There is no freedom of speech. If you vote against the party whip, you are liable for disqualification. Link it with Article 105. Suggest a way forward. Supreme Court observations. In such a pilot case, which I am 100% no other student would be able to write. 100%. Supreme Court observations in the Sachin pilot case regarding the Rajasthan political crisis. Way forward would also include the committee recommendations, the Law Commission, the Dinesh Goswami committees. Another question. Should political parties be allowed to issue whips on all legislative matters? Critically examine. All legislative matters or only those matters on which the stability of the government is under threat? Another question. The Speaker acts as a tribunal under the 10th schedule. Discuss the concerns arising from this arrangement. Unless and until you mention in this article the 2-judge bench Supreme Court observations headed by Justice Rohinton Fali Nariman, you won't get good marks. Because the idea should not only be to write an answer, it should be a better answer than your competitor, so that you are able to score well, because after all, it's a competitive examination. Discuss the constitutional significance of the Kyoto Holohan judgment in relation to the 10th schedule, because this was the case in which it was the constitutional validity of the 10th schedule was challenged. The original constitution in 1985, the original 10th schedule of 1985 said that the decision of the Speaker shall be final and binding, which the Supreme Court interpreted in this judgment to say that it is subject to judicial review, because judicial review is part of the basic structure. No constitutional amendment can violate the basic structure. And 10th schedule was inserted via Article 368 through a constitutional amendment. Is there any other question? Mass resignations have emerged as a means to circumvent the anti-defection law. Examine. Resignation is now a new loophole in anti-defection law. I want to defect, but first I resign so that I can be made a minister as well. Because a defector cannot be appointed as a minister or to any remunerative political post. But if you have resigned, you don't attract disqualification. Resign from house. If you resign from your party, you are disqualified. If you resign from house, no disqualification. Unless and until we have to see, the Speaker has to see the timing. What came first? Your violation of the party discipline or your resignation? These are the matters that you have to keep in mind necessarily. The anti-defection law has strengthened governments but weakened legislatures. There may be a stable government, but are the legislators doing what is constitutionally mandated? Perhaps no, or perhaps yes, because a stable government can focus on the delivery of goods and services. Before this law, more than 50 state governments were dissolved, dismissed, or they lost power because of defections. After this law was enacted, there's a positive side as well. The stability of the governments have strengthened. But has it completely resolved our problem of Ayaram Gayaram politics? Perhaps no. So in this session, what we discussed, answer writing approaches, but we also discussed one topic. And this is how you need to cover individual topics to understand the length and breadth of that topic, link it with current affairs, important observations which are going on, so that you have a holistic understanding of that topic. And now I'm pretty sure no matter what topic, what question is framed from anti-defection law, you should be able to answer. Right or wrong? Okay, that brings us to an end of the session. We'll see you again very soon with more mains-based content on this channel. And for that, you need to subscribe to our YouTube channel if you haven't yet. Thank you for watching. Good night.